So just to begin here, hopefully you're all aware that obviously wellness programs are subject to HIPAA regulation. HIPAA was passed in 1996. The HIPAA non-discrimination rules are what we're talking about here when we talk about the tri-agency guidance. HIPAA is in the Internal Revenue Code, it's in the Public Health Service Act, and it's in ERISA. So you have three agencies with enforcement authority. You have HHS over carriers vis-a-vis the PHSA. You have ERISA, you have DOL over employers vis-a-vis ERISA. And in theory, you have the Internal Revenue Code and the IRS also over taxpayers, which would include an employer plan sponsor. As a general matter, most of the enforcement authority under HIPAA and even the interpretive authority has been resting mostly with DOL. Congress, so there were HIPAA non-discrimination regs implemented in 2007. Those are what we call the old HIPAA regs, because we'll talk a little bit about the new HIPAA regs. But those HIPAA regs, as you may recall, set up a series of different rules, and we'll walk through them based on the nature of the plan, whether it was a participatory, activity-only, or an outcomes-based program. Well, Congress, when it enacted the ACA, as I mentioned, basically said, we like wellness. We think wellness is good. We think wellness programs lead to education around employee risk. It helps drive people to healthier behaviors. It's a good thing. And so Congress basically said, you employers don't even have, you employers can go more than 20% of the premium when fashioning your reward for your plan. So if the premium is $1,000 under the old HIPAA rules, it could be 200 of 1,000. Congress said, go for it, employers, go to 30% or 300. Interestingly, most employers don't go anywhere near the 20% ceiling or even the 30% ceiling. But Congress was clearly looking forward and saying we want employers to use wellness and really to use financial tools as a way to drive employers to better behavior. It also allowed you to use a reward of up to 50% for qualified smoking cessation programs. So that is a very significant surcharge or penalty, right? So if I charge $1,000 for my health care, if you're a smoker, I can charge $1,500, right? It is a very significant penalty. As I mentioned, though, we have a problem because while we have these very specific and very enumerated HIPAA non-discrimination rules issued by IRS, issued by DOL, issued by, who am I leaving out here, HHS, we have these other federal statutes in the form of ADA and GINA. And the ADA and GINA statutes, there is some enforcement authority that vests with the EEOC. And that is what gave rise to the issue in the three cases we're going to talk about today. Just as background, hopefully you're all aware, right, here we are, HIPAA prohibits discrimination with regard to eligibility, benefits, or premium discounts based on a health factor, right? What is your BMI? What is your glucose? What is your cholesterol? You have to participate in an activity-only program, which involves walking 1 mile a day, 3 days a week. But someone may not be able to walk, right, because they have a disability or because they have some other sort of medical condition that makes it difficult to perform that activity-only program. There is an exception for certain programs of health promotion and disease prevention. We call them HIPAA wellness programs. As you see there are three categories, and this is actually really important for our conversation today. There's participatory only, there's participatory, activity only, and outcomes based. When we talk about the HIPAA non-discrimination rules, they actually don't say much about participatory only. We've often talked about the HIPAA hoops or the HIPAA criteria. You know, you have to notice a reasonable alternative standard. You've got to do all these things to comply with the HIPAA non-discrimination regs. Those apply only to activity only and outcome based. HIPAA non-discrimination rules do not really create any meaningful restrictions or rules as it relates to participatory only. When we think of a participatory-only program historically, DOL has said things like complete a health risk assessment or complete a biometric screen where the results are irrelevant, all that matters is participation, right? If I take the biometric screen and I then measure the results of the individual against a standard, right? What is their glucose against a standard or cholesterol against a standard or BMI against a standard? Now I'm in outcomes-based. But if I'm just saying you have to participate, and it's not based on physical activity, I'm in participation only. And HIPAA doesn't really say much about participation only. And as we move forward in our conversation today, what we're going to talk about is the EEOC is seeing HIPAA at minimum, is not doing a good enough job on participatory-only programs. So as we talk about what the EEOC might do with their rules and what they might look like, it's pretty clear to me that EEOC will be doing something on participation only, unless Congress does something first. What they do on activity only and outcomes-based remains to be seen, and we'll talk about that as well. So the ADA, Americans with Disabilities Act, this is a law that is solely in the purview of the EEOC. GINA actually divides up enforcement authority amongst several different federal agencies. The ADA is solely the EEOC's. They have sole interpretive authority, they have sole enforcement authority, and the EEOC, unlike most other federal agencies, when we talk about IRS, DOL, Treasury, there is a secretary. That secretary reports to the president. When the president says, don't do something, the secretary obviously says, okay. Or more specifically, when one of the president's men or women in the West Wing say don't do something, IRS, Treasury, DOL say okay. The EEOC is a quasi-independent agency. Commissioners are appointed for a period of time. It does not report up to a federal to the president, to the administration at all in the same way. And as a result, the EEOC is a little bit like a wild horse. There is a fence around it, right? On the other hand, if it's working within that fence, really there's not much you can do. And we saw that this summer, this fall, with the litigation that ensued. The ADA says an employer can't ask for disability-related information or medical information except in two circumstances. One is a voluntary wellness program, and the other one is a bona fide benefit plan exception. With a voluntary wellness program, basically, we think, gosh, that's really great. What does a voluntary wellness program mean? And we as employers who desperately want to be able to do the right thing say, just tell us what the rules are, and we are going to do a voluntary wellness program, EEOC. And so we'll talk about it in a few minutes, but the EEOC has not been able to date to give any clear guidance around what it means to be a voluntary wellness program. They have issued enforcement guidelines to their regional offices that say a voluntary wellness program is one that does not penalize. What does it mean to penalize? Nobody knows, right? I mean, people would like the EEOC to say it is a voluntary wellness program if it complies with HIPAA. And the EEOC says we are not sure we are on board with that. Right, we get that there's HIPAA, and you guys have control over HIPAA, you three agencies, but we have control over the ADA, and we have a special congressional directive, and we are not sure we're on board with that definition of voluntary wellness program. Bona fide benefit plan exception has been to date the savior for employers, in part because it doesn't actually involve a factual discussion around what is voluntary. And so the ADA includes an exception for bona fide benefit plan underwriting. And if you look at the legislative history, which was cited quite a lot by the EEOC Office of Legal Counsel in their briefs, they say this was really about allowing brokers and carriers to make inquiries for commercial underwriting purposes. Right? This isn't a world where you have group underwriting. So we need to allow those carriers, those brokers, and the employer in connection with purchasing healthcare to make inquiries of individuals as needed to get the coverage. Well, employers have said, no. This actually goes to our wellness program too. Because if you look at it, our wellness program is about managing risk. And we certainly, when we're figuring out how much incentive to provide, how much cost a program has, we are looking at the wellness program as a way to reduce risk and a way to reduce cost. And interestingly enough, one thing that's actually helped employers, even though it drives you crazy, is that under the current rules, you can't have a wellness program that offers any material medical benefit unless it's part of your group health plan. And that is because your wellness program is not a HIPAA accepted benefit. So HIPAA accepted coverages are outside of all the ACA's market reforms. First dollar preventive care, claims and appeals rules, all these things. Right? But if you have a wellness program that has biometric screens, it has chronic disease management, It has anything that would be a 213 medical expense. The program needs to be inside your medical plan, and it only probably needs to be available to your medical plan participants. Otherwise, you risk having a plan that is non-compliant with the ACA market reforms. But that fact alone has caused employers to direct their wellness programs to their major med plans, which has allowed them to make an easier and better claim that the wellness program is a term of their major medical plan. It is part of the underwriting practice. It is about managing risk. And we saw this argument make great success in a case called Broward v. Seth v. Broward County, which was a class action brought down in Florida, and the employer argued, no, our wellness program, it argued two things. It's voluntary, and it fits within the bona fide benefit plan exception. And the court said, you're right, it fits within the bona fide benefit plan exception. It's a term of the plan. It's about managing risk. You're good to go, county, class, go pound sand. EEOC, Office of Legal Counsel, hates this. They think this totally guts the ADA protections. Their point is, well, then why would we have an exception in the statute for a voluntary wellness program if any wellness program can avail itself of the Broward County bona fide benefit plan exception? We will definitely see litigation around this in the future unless Congress solves it for us. Sorry, I'm giving a lot of information. I was going to say nod your head if it's helpful, but I fear no one's going to nod their head. So the other act that's really important and that came up in Honeywell and the litigation was GINA. GINA is the girlfriend to Ada. No, GINA is the Genetic Information Non-Discrimination Act. And there are two titles, Title I and Title II. But what it generally prohibits is basically collecting genetic information for underwriting purposes. Interestingly enough, when we talk about wellness programs, we say you can ask or make people do pretty much anything they want as long as it's voluntary and fits within HIPAA, and you can even give them a financial incentive. With GINA, you can never ask someone for genetic information and give them a financial reward. Can never be done. It has to be, the financial reward has to be disconnected from the request for genetic information. And so GINA is a different, more rigorous statute. Interestingly enough, and this will come back to be very important, genetic information includes current medical information of family members. So my mother's current medical information, that she has cancer, that she has diabetes, that she has been diagnosed obese, those things are my genetic information. Similarly, my child's medical information is my genetic information. Now, here's what causes the GINA problem in the context of most wellness programs and was raised in Honeywell. My wife's current medical information, under the statute, not under crazy agency regs, under the statute passed by Congress, my wife's current medical information is my genetic information, right? And why was that? And if you talk to the drafters on the Hill, when they drafted language, they said, well, we were worried that somehow employers and carriers would look to the wife's information and then say you could create a child that would have a predisposition or a marker for certain conditions and would therefore be discriminated against. So the basis of why they did it was the idea that my wife and I would create a child, and my wife's current information is relevant to me because the two of us together could create something, a child that would have some sort of predisposition. Anyway, it's caused a huge GINA problem. It plays out in Honeywell. We'll talk about it. It drives employers crazy. Title I applies to health plans and issuers. This is really important because the EEOC doesn't really care. And this was a huge jurisdictional argument made by Honeywell in its litigation. So Title I applies to group health plans and issuers. So if I have a plan and I have a GINA violation, in theory, Title I applies. The only people who can enforce Title I, DOL, IRS, HHS. I did not mention EEOC, right? So if I have a group health plan, I've got a GINA violation. So Title I applies. So let's say under my medical plan, you have to provide genetic information in order to get a benefit. seems like Title I clearly applies. Title II, if I say to an employee, in order to get hired, I want you to give me your genetic information, there's no plan, right? That's a Title II. That's an employment-based discrimination with respect to GINA under Title II. There is a firewall. You are not supposed to be liable under both Title I and Title II. It's really supposed to just be one or the other. Well, the EEOC, Office of Legal Counsel's representatives have said in public statements that they don't really believe that the firewall sits where it sits. Their view is the employer, in their act as either settler or fiduciary over the plan, has contracting authority, and they are entering into the contracts that create what happens inside the plan, and therefore they believe Title II can leak on over and apply to your group health plan. Employers, of course, are saying, no way, that's totally contrary to congressional intent, that can't be the way, we're in Title II, EEOC go pound sand. And that's what Honeywell said in its briefing before the Federal District Court. We'll talk about that as well.